Hello everyone, this is Urvashi Chauhan and you are watching Courts Today by Livelaw, your one-step destination to all legal developments in the country. Let us start. Starting with an update from the Supreme Court. You are aware that the top court is seized of the contempt case against Patanjali Ayurved Limited over publication of misleading medical advertisements in breach of an undertaking given by it to the court. Today, the bench of Justices Hima Kohli and Ehsanuddin Amanullah heard the petition filed by the Indian Medical Association against Patanjali's advertisements attacking allopathy and making claims about curing certain diseases. The bench had previously issued a contempt notice to Patanjali Ayurved and its MD, noting that it continued misleading advertisements despite the assurance given by their counsel last November before the court that it would refrain from making such advertisements. On the last date of hearing, after noting that the reply to the contempt notice was not filed, the court went on to pass an order seeking the personal appearance of company's MD Acharya Balkrishna and co-founder Baba Ramdev, who also featured in the press conferences and advertisements published after the undertaking given to the court. Today, let me tell you, both Balkrishna and Ramdev were personally present before the court. Senior advocate Balbir Singh, who appeared for Baba Ramdev, submitted that the parties were ready to apologize in person. But on noting that Baba Ramdev's affidavit was not on record, the court said that if the parties wanted to apologize, then they should have filed proper affidavits. After hearing the counsels, the court granted Baba Ramdev the last opportunity to file a reply. The court also wondered why the union government had not taken any legal action against Patanjali Ayurved for claiming that its products could cure COVID-19 pandemic. The court said that though the claims were made by Patanjali at a time when COVID was at its peak, the union did not take any action, although its own committee had stated that the products of Patanjali could be used only as supplementary to other medicines. The court has listed the matter for 10th April, directing both the parties to be present on that day as well. Stay tuned with Livelaw. In an important update, the Supreme Court has today granted bail to Aam Aadmi Party leader and Rajya Sabha MP Sanjay Singh in the money laundering case related to the Delhi liquor policy. He was arrested last year in October following searches at his residence in Delhi. Enforcement Directorate alleges that an employee of businessman Dinesh Arora delivered 2 crore rupees to Singh's house on 2 occasions. After Singh's arrest, Arora turned approver in both the ED and CBI cases. The bench comprising Justices Sanjeev Khanna, Dipankar Datta and P.B. Varale heard the matter today. Singh's counsel, Senior Advocate Abhishek Manu Singhvi, emphasized that the entire ED case against Singh was based on the statement of approver turned Dinesh Arora, who in fact made 9 exculpatory statements before finally naming Singh. For those of you who do not know, exculpatory statements are those that tend to clear or absolve someone from blame or guilt in a given situation. When Additional Solicitor General S.V. Raju, appearing for Enforcement Directorate, said that it had no objection to grant of bail, the court ordered Singh's release, clarifying that nothing was being expressed on merits. The court orally observed that no money had been recovered from Singh. With bail, the court has allowed Singh to indulge in political activities during the period of bail. But at the same time, he is not supposed to make any public statement regarding the case. On the request of the ASG, the bench clarified that the concession given by ED would not be treated as a precedent. Furthermore, emphasizing that PMLA is intended for forfeiture of laundered money, the bench requested the counsels to deliberate on a question that, while not directly relevant to the current case, pertains to whether the PMLA would apply if an individual is caught in the act of accepting a bribe. While highlighting faulty investigation in a money laundering case, the Delhi court has said that the Enforcement Directorate must introspect as to what steps are required to be taken by it for ensuring expeditious and fair investigation in all the cases. Special Judge PMLA Mohammad Farooq of Rouse Avenue Courts was dealing with a complaint filed by Enforcement Directorate against 5 individuals for alleged commission of offences under Prevention of Money Laundering Act, that is PMLA. It was alleged that in 2009, the accused persons conspired among themselves to forge and fabricate 8 checks. 3 checks were encashed and around 1 crore 46 lakh was credited to bank accounts operated by 2 accused persons, causing wrongful loss to Punjab National Bank and its account holders and wrongful gain to themselves. Further, it was alleged that the accused attempted to encash the remaining 5 forged and fabricated checks. However, the forgery of the checks was detected by bank. Also, one of the individuals died during the trial. The court pointed to certain defects in ED's probe. The court criticized the IO, that is the Assistant Director ED, for not prosecuting 2 individuals as accused in the case despite ample evidence that they assisted the primary accused in laundering of proceeds of crime. The court said that ED did not take steps to trace the whereabouts of one of the individuals or take coercive steps against him. The court said that the IO failed to conduct any investigation as to who were the persons operating the bank accounts and under what circumstances the tainted money was credited to such accounts. The court observed that there was not only undue, unwarranted and unexplained delay for over 9 to 10 years in presenting the charge sheet, but also the investigation was faulty. Further, the court convicted 2 accused in the case and acquitted the other 2 accused persons. It summoned the 2 individuals regarding whom it criticized the IO and directed for the trial to be conducted afresh. The judge said that it had to be ensured that there are sufficient checks and balances in place for ED's investigating officers to act with expected urgency and diligence in respect of every investigation. Coming to another update from the Supreme Court. If you remember, the top court in February had lifted a stay imposed by the Madras High Court on ED summons against the district collectors of Tamil Nadu for investigating the money laundering case arising from illegal sand mining activities. To give you a brief background, while investigating the alleged illegal sand mining and money laundering cases, ED had issued summons to district collectors in Tamil Nadu. Against this, the state of Tamil Nadu approached the High Court, which suspended the summons but allowed the investigation to continue. So against this order, ED approached the Supreme Court in an SLP. The top court granted interim relief and directed the district collectors to appear and respond to the summons. After this, on 1st March, ED issued fresh summons to the district collectors. The collectors, instead of appearing, sent replies to ED seeking postponement, stating that they were engaged with duties in connection with the upcoming Lok Sabha elections and were discharging social welfare schemes in districts. They also stated that they did not have the data related to mining and sought time to collect the same from other offices. Today, a bench comprising Justices Bela Trivedi and Pankaj Mittal was considering ED's petition against the Madras High Court's order. Strongly deprecating the officers' approach, the court stated that their conduct showed that they did not have either respect for the court or the law, much less the Constitution of India. Considering that the elections are set to occur in Tamil Nadu on 19th April, and acknowledging the statement by Senior Advocate Kapil Sibal on their behalf that the officers were gathering data from relevant departments, the court decided to grant them another opportunity to appear before the ED in response to the summons issued. In another update, the Madras High Court has temporarily stayed the central government's circular dated 12th March, which had prohibited the import, breeding and selling of dogs classified as ferocious and dangerous to human life. The interim stay was granted by Justice Anita Somnath on a plea filed by the Kennel Club of India. Seeking to quash the central government circular, the club's plea said the circular was issued pursuant to an order of the Delhi High Court, that the High Court had unequivocally held that all stakeholders had to be consulted before taking an action. But the Kennel Club of India, though being a major stakeholder and having chapters all over the world, was not consulted. The club further argued that to identify a particular breed of dog to be ferocious and dangerous to human life required profound expertise for identification and to see whether the dogs were appropriately trained or not. The club submitted that no such expertise had been gone into while passing the circular. The Allahabad High Court has today expressed its displeasure at the high-pitched slogan shouting which took place in the corridors of the court during court hours. The Allahabad High Court Bar Association elections are set to take place tomorrow, and the candidates and their supporters campaigning in the corridors of the courtroom were shouting slogans at high volume. The slogan shouting was at such high pitch that it created obstruction in the court proceedings and did not allow the court to hear the case due to excessive noise on both sides of the courtroom. The bench comprising Justice Manoj Kumar Gupta and Justice Kshitij Shailendra was informed that according to the Model Code of Conduct, such kind of slogan shouting is prohibited. The court has directed the Registrar General to inform the returning officers and a representative of the Elders Committee to appear before the court and has directed the Registrar Protocol to preserve CCTV footage of the incident. And lastly, the Bombay High Court has held that having a heavy goods vehicle, that is HGV driving license, does not make a person ineligible to drive a light motor vehicle, that is LMV. This is because Section 7 of the Motor Vehicles Act provides for a minimum 1-year-old LMV license as a prerequisite for HGV license. With this, Justice Shiv Kumar Dege set aside a judgment by which the Motor Accident Claims Tribunal had refused to hold an insurance company liable in a motor accident on the ground that the offending vehicle was an LMV, but the driver possessed a driving license for HGV. The court here allowed the appeal filed by the owner of the offending car in an accident with a motorcycle challenging the tribunal's order. Thus, the court directed the insurance company not to recover the compensation amount from the vehicle owner. Thank you for watching. If you wish to know more details about the cases I mentioned here, you can visit our website at www.livelaw.in. Stay ahead with quick legal updates only on Live Law. Do not forget to like, share and subscribe and support us. You can also support us by donating through the thanks button at the bottom of our videos or consider becoming a member at just 89 rupees per month.